Big victory for free speech and First Amendment protections after a court decided one school district's pronoun policy violated students' constitutional rights. The federal appeals court ruled a school district in Ohio could not punish students who do not call a transgender student by their preferred pronoun. It is a legal decision that's going to have precedents across the country, and it's all thanks to a lawsuit filed by Defending Education. The senior director for communications there, Erica Sanzi, joining us now with more on this massive win for the organization. Good morning to you. Good to see you. Happy Friday.
Good morning, Jan. Thanks for having me.
Of course, you know, this case, as we know, has been going on for 2 years. Your organization states that it is the most expansive defense of student First Amendment protections since the 1960s. So walk us back a bit. Tell us about the lawsuit and how this all began.
So in 2023, our organization sued the Olentangy local school district in Ohio over their harassment policies and codes of conduct that clearly violated students' First Amendment rights by compelling students to use preferred pronouns to affirm the gender identity of their classmates and peers, even if doing so was contrary to their, deeply held beliefs. And if students had failed to comply with using those preferred pronouns, they faced punishment that ranged from, no contact orders to suspension and even expulsion. So this was clearly a problem on First Amendment grounds. But what's interesting is that this was a long process for us because we lost in the lower court. And so we appealed to the Sixth Circuit. And then when you appeal, your case gets heard by 3 judges in that circuit. So we lost again. So then we did something that I would never have known about this until I was part of an organization that did this. We petitioned for something that's called an en banc hearing, which basically means that the whole bench of all the judges in the Sixth Circuit would hear your case. So our attorneys felt that we were on such solid ground that if we could get all 17 judges to hear the case, we would win. And we were granted that petition to have the whole bench hear the case. And so we ultimately were victorious with 10 of the judges siding with us and 7 against. So this was a slow and steady wins the race sort of process. But yeah, in the end, it came out on our side. And this is a very big win for the First Amendment in schools, because again, it's not that you can't use preferred pronouns or out of whether it's courtesy or just kindness or you don't care about it or it does align with your beliefs, but you cannot force students to use them if they don't want to.
Yeah, I was reading the decision here, and put differently, I think as your organization mentioned, pronouns have the power to validate or invalidate someone's perceived sex or gender identity, and schools cannot effectively compel their preferred viewpoint. I want to read what Defending Education President and founder Nicole Neely said. She said, "We are deeply gratified by the Sixth Circuit's intensive analysis, not only of our case, but the state of student First Amendment rights in modern era. The court's decision and its many concurrences articulate the importance of free speech, the limits and perils of public schools claiming to act in loco parentis, and the critical role of persuasion rather than coercion in America's public square." And loco parentis, by the way, is in place of parents, is what that means,
yes,
which is really the crux of so many of these cases where common sense is now prevailing, and parents are telling these quote educators to start teaching and stop trying to replace what they are doing at home. What kind of reaction have you received from this? What's the school district saying as a result?
I haven't actually seen any reaction or comments from them yet. Also, just for the audience, the Sixth Circuit is Kentucky, Michigan, Ohio, and Tennessee. So those are the states where school districts would have to get in line sort of immediately. But now we have this really strong precedent so that it can be used in cases across the country, because this is not an unusual policy, right, in school districts. But yeah, I mean, I've seen a lot of celebratory commentary among lawyers and on both sides of the aisle, I think, because they felt that this was such a First Amendment violation. But certainly there's been outcry online about, some people think that, I think they've accused our organization of supporting bullying. But really, when you think about it, the bullying is telling students what they can and cannot say. So this is a huge win for us. And another example, I really think that sometimes it is that sort of slow and steady does win the race. And in this case, it took a long time, but it turned out really well for us.
And quite frankly, bullying can work both ways. Both
Exactly. I
ways.
mean, if you make me say something, if you're making me say something that I don't believe, that kind of seems like it's bullying too. So again, this is a huge win, and I do think it's going to have, you know, an important ripple effect moving forward.
All right, Senior Director for Communications, Erica Sanzi, always great to see you. Thanks for joining us this morning.
Great to see you. Thanks, Jan.